So let's talk about now a couple's situation. When I say a couple, I mean somebody who's married or is a registered domestic partner. If you are in a couple's situation and you're not either one of those, but you are in what we call a committed intimate relationship, then you can bet that there is going to be a lot of litigation involving who gets what. Because even if you're not married, but you've been in a situation where you've held yourself out to be like in a marriage and you don't have a will, that person who is that surviving not spouse is going to have equitable claims as if they were a spouse. Now, why does all of this matter? The reason that this matters is that when one person of one party of the couple dies, it opens up everything for investigation and determination and analysis. It makes everything so much more complicated than it ever needed to be if you had an estate plan. Think of it this way. This is how I think of it. A well thought out estate plan is like a gift to your family, a gift to your loved ones. It makes everything that was messy and tidy and makes it neat, messy and untidy, and makes it neat and tidy, like in a gift box. And sadly, when you pass, what's going to happen? Well, you open the gift box and, oh, here's what the plan says. It says everything goes here or there, or it's divided this way, or the plan's been set up to avoid probate, or if there is a probate, because there's a good reason for it, who's going to be the personal representative and who gets what without having to dig into that person's life too far. Contrast that, a nice, neat, and tidy estate planning package with no estate plan at all. It gets messy. Why does it get messy? It gets messy because when you are married, and I'm talking about Washington State, and we all know we're a community property state. Is everything community property? And why do we even ask that question? Well, the reason that we ask that question is because the laws of intestacy provide different results for different characterizations of property. So I believe you are seeing my screen here that talks about, are you married? And if the answer is yes, then we go down the analysis tree. And if you have living descendants, that means your spouse gets 100% of the community property and 50% of the community property. And then your descendants get the other 50% of the separate property. So CP here means community property, SP means separate property. And then we go on and we talk about things. So why am I spending this much time talking about separate and community property? Well, obviously, it's because it gets divided differently. Community property goes to the surviving spouse. Separate property gets divided between the surviving spouse and the children of the decedent. Okay, we have now opened a box to inquire, well, what's community property and what's separate property? And there's a lot of misunderstanding about this. Just because you live in the state of Washington and you are married doesn't mean everything you own is community property. And I'm coming from the perspective of you haven't done an estate plan. You haven't done a community property agreement. You haven't clarified what is what in terms of property. Basically, just the general rule is that whatever you acquire from having been in a marriage and either both of you work or one of you works, and then you buy your house and you pay your mortgage together, that's going to be community property. This is something from your earnings, from your joint efforts. That's community property. And remember, community property, let's say it's the house, will go 100% to the surviving spouse, which is what the state thinks that you would have wanted. And it makes a lot of sense because you don't want the surviving spouse to have to move from the marital home or sell it. But what if that house was not purchased from community funds during a marriage, But what if that house was something that was bought by one of the spouses before they got married, and their name of the deceased spouse is the only name that's on the title, and community funds weren't used to pay off a mortgage? Maybe that person bought that house with their own separate funds or an inheritance they received. Inheritances are separate property. So if that house was purchased by somebody, even during the marriage, and it was bought with separate property funds from an inheritance, that separate property, unless there are some actions to make it community. What actions might that be? That might be adding the spouse's name to the title. But if that wasn't done, or if the property was acquired before the marriage, and separate property is what was used to either purchase it or pay off any mortgage, that's separate property. Okay, so what happens then on the death of that person? It's their separate property. Where does it go? 1/2 to the surviving spouse and 1/2 to the children of the deceased spouse. You can see how problematic that would be to the surviving spouse who has just lost their husband, for example. And now what are they supposed to do? Take out a mortgage? How do they pay off the child's 50% interest in that house? Do they have to sell it? Do they have to move? It can be a terrible result. That is probably not what you intend to do to provide for your surviving spouse. If you do, make it clear. Make it clear in a will. Make sure that you've thought through all the implications and consequences of, if you want to give your interest in your house, only half and half, make sure you have a good, well thought out plan for how that impacts people. Of course, I'm talking about the laws of intestacy, which means you don't have a plan. You're relying on what the state statute says.